Hello.
Good evening to one and all. I deem it a great honor and privilege. Sound. Good evening to one and all. Okay. I deem it a great honor and privilege to welcome you all to this August function. Karnataka Mediation Center is conducting the continuing mediation educational program on second Thursday of each month with the guidance and blessings of Board of Governors, Karnataka Mediation Center. This live streaming of CME program is going to be watched by mediators of Karnataka state, including the mediators of Dharwad and Kalburgi benches. I extend my warm welcome to Honorable Mr. Justice Srinivas Harish Kumar, Honorable Judge, High Court of Karnataka and President of KMC. I extend my warm welcome to Honorable Mr. Justice S.G. Pandit, Honorable Mr. Justice Ashok S. Kinigi, Honorable Mr. Justice Suraj Govindraj, Honorable Mr. Justice Jyoti Mulimani and Honorable Mr. Justice M.I. Arun, Judges of Arnott, High Court of Karnataka and Governors of Karnataka Mediation Center, Bangalore, who are watching this function virtually. I extend my warm welcome to Assistant Director, Karnataka Judicial Academy, Messrs. Amrita Sindhur. I welcome Assistant Registrar General Shri Ron Vasudeva and Assistant Registrar Judicial Shri Venkatesh Hulgi. I welcome all the judicial officers, our Director, Deputy Director of KMC for the efforts and cooperation extended by them to have continuous educational program through this function. I also welcome all the master trainers of Karnataka Mediation Center, all the coordinators and all the mediators and staff of Karnataka Mediation Center who are present here and also watching through virtually. I welcome Additional Registrar Computers, Additional Registrar General and Additional Registrar Judicial of Bangalore, Dharwad and Kalburgi benches. I welcome to Shri Jai Shankar, Member Secretary KSLSA, Shri Raghavendra Shettiar, Deputy Secretary KSLSA, Shri PM Balasubramani, PRO KSLSA, Shri Sharat Chandra N, Assistant Secretary KSLSA. I welcome the Honorable Mr. S.R. Somshekara, Retired District Judge, Rural, and I request Mr. Zahir, Mediator and Coordinator of KMC, to offer the plant to our Chief Guest, Shri S.R. Somshekara, Retired District Judge of Bangalore, Rural District. Honorable Justice Shri S.R. Somshekara practiced as an advocate from 1979 to 85 and later joined the judiciary as Munsif in 1985. He was also a principal judge of Madikeri, Kodagu, and he retired as Principal Judge, District Judge of Bangalore Rural District in the year 2016. He was also served as a Deputy Director and Additional Director of Karnataka Judicial Academy, Bangalore. Even though he served as a judge in different districts of Karnataka state, his primary concern is to help the advocates and professionals. Even during Corona, he used to educate the professionals by webinars through VC. Even though he retired from service, because of his hard work and knowledge, the Honorable High Court of Karnataka recognized him and given an opportunity as special invitee to the pending and progress of POCSO committee. Now I request our chief guest, former Justice Mr. S.R. Somshekara, to share his experience and thoughts to enlighten us by this continuous education program, especially in respect of Bharatiya Sakshya Adhiniyam 2023.
No problem. ಯಾವ ತೆಗೆದ್ರು ಕೊಡಲ್ಲ ಅದು ಮೈಕ್ ಇದ್ರೆ ಸಾಕು. ಓಕೆ. Good evening. At the outset, I thank. You are able to hear me? At the outset, I thank the President and all the Honorable Governors of the Karnataka Mediation Center and Director of the Mediation Center for having given me an opportunity to speak on Bharatiya Sakshya Adhiniyam of 2023, which is yet to come into force. I also express my deep sense of gratitude to Honorable Shri Justice S.G. Pandit and Justice Shri S.R. Kiniji, who have joined online. I am also happy that my good friends, number of mediators are here. Some reverend judge once said, I am in the intimidating presence of learned people. It is a fact, because you are all senior advocates, trained mediators, and many judicial officers known to be are here. I am quite conscious of the composition of this audience, who are already in the field and who know what the Evidence Act is. You might have also gone through the provisions of the new Adhiniyam of 2023. So I am conscious of the composition of this audience, and I am also conscious of my own limitations and limitations of time also. But what best I could do in this 1 hour, let me make an attempt. That is why, in consultation with her, we have carefully captioned the subject as a bird's eye view of this Adhiniyama. Now, the basic three enactments, IPC, CRPC and Evidence Act, were sought to be replaced by 3 Adhiniyamas of 2023. The newspaper reports gave me an indication, probably to all others also, that the purported object of replacing those enactments was to Indianize the legal system, to see that the British vestiges are no longer found in the 3 enactments and in the legal and judicial system. In the book that I have also the speech of the Union Home Minister made in the Lok Sabha when the bills were introduced. There is some slight indication in his speech that the purported object of the enactment was to that effect. But from his speech and from the statement of objects and reasons which I find the enactments, particularly this Bharatiya Sakshya Adhiniyam, I have noticed that the main object was to see that the present law is in tune with the Information Technology Act and the technological progress that the country has made in judiciary and in the legal field. But the question is whether there are no provisions at all regarding electronic evidence, electronic records, digital records in the Indian Evidence Act before this Adhiniyama was drafted. There were provisions, all of you are aware of it. In fact, you are more conversant with that, you are more adept at that, and you know better than me as to what it is. There were a few particular sections in the Indian Evidence Act of 1872, since they were all insertions in tune with the Information Technology Act. Obviously, they were given numbers as 88A, 89, 88B like this. What the Adhiniyama has done is remove those A, B, C and made them an independent section. The Indian Evidence Act of 1872, as all of us know, is divided into three parts: relevancy of facts, proof of facts, and production and effect of evidence. Strictly speaking, it is from section 5 ending with section 55. The first part relating to relevancy of facts is contained. But in chapter 1 itself, where there is short title Extent Commencement Interpretation Clause, that chapter itself is titled as Relevancy of Facts, and that is also shown as part 1. What has been done in this Adhiniyama is, part 1 contains the definitions, part 2 relevancy of facts, part 3 proof of facts, part 4 production and effect of evidence. The Evidence Act of 1872 has totally 167 sections. We have now 170 sections in this new enactment. I have just gone through them. It is not that I have made an intensive study nor a critical study of it. I have just cursorily gone through. It can be taken as an extensive study and not an intensive study. I find that there is a verbatim reproduction of many of the provisions of the Indian Evidence Act 1872, as also many of the definitions, most of the illustrations given to various sections. For example, in section 11 of the Indian Evidence Act of 1872, it says, facts not otherwise relevant are relevant if they are inconsistent with a fact in issue or a relevant fact, or when they by themselves are in connection with certain other facts made the existence or non-existence of a fact in issue or a relevant fact highly probable or improbable. The first illustration given to that section speaks of the plea of alibi that an accused takes in a criminal case. Some places like Lahore and Calcutta are referred. In the new enactment, the places are changed as Chennai and Calcutta are so. Barring that, I don't find any such difference. Then, 28 of the Indian Evidence Act of 1872 should have been actually a proviso to section 24, okay, or immediately after section 24. But anyway, when the Evidence Act of 1872 was drafted, it was put as an independent section, slightly removed from section 24, 3 or 4 sections later. Now it is 24.1, 24.2 like this. 27 is also given a new section. So these are some, if I can put it with some amount of confidence, a cosmetic change in the Act. When it comes to electronic records, particularly section 65B, there are certain expressions found in the enactment of 1872. Something more is added, semiconductor and other things. Some technical knowledge is required, knowledge of physics, engineering is required to understand those concepts. There are better people who can speak about it. Barring that, I don't find much of a change, a verbatim reproduction of the enactment of 1872. This is what I intend to tell. Having said that, let me just here and there touch upon a few provisions, also read the statement of objects and reasons. So, when the bill was introduced also, obviously a statement of objects and reasons was prepared. The same thing is found after the act was enacted, and that also is found in the whereat of these enactments. I just read it only to know what the purported object of the enactment is and how it is sought to be achieved and how in fact it is achieved or not achieved. I will leave it to the enlightened audience to decide whether the purported object is achieved or not. This is the statement of objects and reasons accompanying the bill. Same thing is reproduced in the Act. The Indian Evidence Act 1872 was enacted in the year 1872 with a view to consolidate the law relating to evidence on which the court could come to the conclusion about the facts of the case and then pronounce judgment thereupon, and it came into force on 1st September 1872. The experience of 7 decades of Indian democracy, obviously from 1947, calls for comprehensive review of our criminal laws, including the Indian Evidence Act, and adopt them in accordance with the contemporary needs and aspirations of the people. The law of evidence, not being substantive or procedural, falls in the category of adjective law that defines the pleading and methodology by which the substantive or procedural laws are operationalized. The existing law does not address the technological advancement undergone in the country during the last few decades. But I find that the existing law has also taken care of that aspect to some extent, and here and there, as I said, the new Adhiniyam just elaborates those definitions, enlarges those definitions. A few technical terms are found there. This is the purported object. Now, as I already said, in the Act of 1872, the interpretation clause is found in section 3. To this enlightened audience, I need not tell, in most of the enactments, that particular section is section 2, that is definitions. In some enactments, the Transfer of Property Act and Evidence Act, the definition section is styled as interpretation. So, the old, not old, still existing Evidence Act of 1872, in interpretation clause, various terms are defined: court, fact, evidence, document, proved, disproved, not proved, and all that. Section 4 has only 3 things, which all of us know: may presume, shall presume, and conclusive proof. Now, these 3 and 4 of 1872 are found in section 2 of the Bharatiya Adhiniyam, Bharatiya Sakshya Adhiniyam. So, I just checked it up. So, let us go to a particular section in the Act of 1872, say section 6. Subtract 2 numbers, you will get 4 here. If it is 8, we will get 6. Somewhere towards the end, we will have to add a few because, as I said, A, B, C are removed, independent sections are made. Why I am giving this preface is, it is not really difficult to understand or know the new Adhiniyama because we have been dealing with this. 1872, we are in the year 2024. For the last 152 years, we have been dealing with the Indian Evidence Act. We have seen number of decisions on this point. All of us are familiar with this. So, with that familiarity, with that knowledge, understanding, experience, or whatever we have, it should not at all be difficult for any one of us, be it lawyers or judicial officers or even law teachers to deal with the new enactment Adhiniyama, just keeping in view the cosmetic changes that have been brought. I must also candidly confess before this audience, I have not gone through the provisions of the other two enactments, that is something equivalent to Indian Penal Code, some Surashchita Samhita or something, for CRPC also. I have not gone through it. IPC appears to have made some changes. CRPC also, here and there are some changes. I have not applied my mind to the provisions of IPC and CRPC, but to this extent, there is an advantage also for me, because for the last 8 or 10 days I am speaking about the Evidence Act itself in the Karnataka Judicial Academy for newly recruited civil judges and district judges. I had that advantage also. I told Srimati Radha that I would speak about this Bharatiya Sakshya Adhiniyam today. Maybe on some other occasion, after I go through the other two enactments, I may with some ease and comfort make a presentation on that. Today I have confined myself, and in 1 hour only that could be done. So at the cost of repetition, I should tell you that the sections are just renumbered, some subsections are given, some new numbers are given. But one needs to be noticed here. In this Adhiniyama of 2023, this section 2 has two subsections. Subsection 1 defines certain expressions. Court. Here what has happened is, the definitions are given in an alphabetical order. In the enactment of 1872, the concept wise, may presume, shall presume, conclusive proof. It is not in an alphabetical order. But it would have been easy for us to understand what is may presume, what is shall presume, what is conclusive proof. Proved, disproved, not proved. Here, since it is given in an alphabetical order, if we just go by the alphabetical order, we will not be able to understand the concept. Since we are already aware of the old Act, the provisions of the old Act, it would not be difficult, though it is not in an alphabetical order. So immediately after the definition of the word court, because we are going by this alphabetical order, we get conclusive proof. Thereafter disproved. Thereafter document, it goes like this. There is one thing about which I must honestly tell you, I had also not noticed it till about 10 years back, 2014, and Srimati Radha was also there on that occasion in the Judicial Academy. I was the additional director, she was the deputy director. We have this definition of not proved in the Indian Evidence Act of 1872. We were told in the law college, and that is how we have also got it by rote. Not proved means neither proved nor disproved. In fact, it goes to the credit of a newly recruited civil judge of 2014 batch, whom both I and Srimati Radha know, that he brought it to our notice that the definition of the word not proved is not we had presumed it to be. In fact, it is a little confusing, but somehow we proceeded on the basis that it is so, and he even told me that he had checked the original text, and that was in the original text also it was this. Actually, what is the definition of this, rather the meaning of the word not proved as given in the Evidence Act of 1872? A fact is said not to be proved. It is not just not proved. But what is it that we were told in the law college? Not proved means something which is neither proved nor disproved. We have all proceeded on that. We understood like that only. There is nothing wrong. A fact is said not to be proved when it is neither proved nor disproved. Of course, something grammatically the sentence may be correct, but the intended meaning is not conveyed. Now, in this Adhiniyama of 2023, that has been corrected. Here we get in section 2I, not proved. A fact is said to be not proved, ali not to be proved antide, illi said to be not proved when it is neither proved nor disproved. Proved, disproved, all of us know it. Then section 2, as I said, it has two subsections. Subsection 1 defines these various expressions. Subsection 2 is an addition. Words and expressions used herein and not defined but defined in the Information Technology Act 2000, Bharatiya Nagarika Surashcha Samhita 2023, that is CRPC, and the Bharatiya Nyaya Samhita 2023, that is IPC, shall have the same meanings as assigned to them in the said Act and Samhitas. So, therefore, this is a new insertion there. Then, sections 5 to 55 of the Act of 1872, they deal with relevancy of facts. Section 5 is in general. Evidence may be given in any suit or proceeding, or the facts hereinafter declared to be relevant and of no others. Instead of section 5, we have section 3 here. The explanation to section 5 is verbatim reproduced in the explanation to section 3. Then, the first group of relevant facts contained in the 1872 enactment are found in section 6 to 16. The second group is 17 to 31 admissions, which includes confessions. 32 and 33 statements made by persons who cannot be called as witnesses to the court. Three categories of witnesses. Those who are not alive, they are alive but not able. They are alive but able but not available. I told junior officers, remember these 3 A's. For a person to come and give evidence in the court, either of these three A's, either he should be alive but not able. Alive, able but not available, he is absconding. In such situations, 32 and 33 say that any statement made by him, verbal or written, can be taken in evidence because it is an exception to the rule of hearsay evidence, because that man is not before us for cross-examination. So, same thing is retained, a different number is given to these relevant sections. The next group of sections is statements made under special circumstances. That is, accounts maintained in the regular course of business, entries in public records, then maps, charts and all that. 35 to 39, that is another group. For that also there is a different number. The next group of relevant facts is 40 to 44, 1872, judgments of courts of justice when relevant. 40, as all of you know, incorporates the principles of res judicata in section 11 and attrifies and attrifies convit article 20 and section 300 CRPC, that principle against double jeopardy. Then 41, conclusive proof, that is judgments of courts of probate, matrimonial, insolvency and admiralty jurisdiction. When they give a declaration, when they pass an order, when they give a judgment, certain facts, certain portions of the order given by them are conclusive. They are judgments in rem. They bind just not the parties to the proceeding, they bind the entire world. That is 41. 42 says judgments which are otherwise not relevant would be relevant only to show the existence of a judgment. That's all. Some illustration is given, the same thing is carried out in the new enactment. And when the very existence of the judgment is doubted, now a suit is filed, an earlier suit was filed by A against B, there is a finding in favor of A or B. In respect to the same subject matter, there is a subsequent suit between the same persons. Obviously, the decree in the previous suit operates as res judicata in the subsequent suit. But if the other side disputes that there was such a judgment, section 43 of the Evidence Act of 1872, which has a corresponding provision in the new Act, says, well, that judgment needs to be proved. Produce a certified copy of the judgment and show to the court that such a judgment was drawn. Now, section 44 of the old Act, 1872 Act, has a similar provision in the new Act also. It is of some interest to all of us because 41 tells us that a previous judgment in respect to the same subject matter between the same persons given by a competent court certainly would bind the parties and they would bind the representatives also, and therefore the principle of res judicata operates and the subsequent suit would not lie. But there is an exception to this contained in section 44. I may give the relevant section of the new enactment also. I will just, in a minute, I will give the relevant section in the new enactment. That is section 38 of Bharatiya Adhiniyam. It is, as I said repeatedly, a verbatim reproduction of section 44 of this. Since I find a few junior members here also, I just have taken the liberty of just explaining to them what 44 of the Evidence Act of 1872 corresponding to Adhiniyama 38 of the Adhiniyama is. So, we have seen under 41 corresponding to 34 of the Adhiniyama, it speaks of the principles of res judicata. 44 corresponding to 38 is an exception to that. What is that exception? If the previous decree is obtained by fraud, by playing fraud on the court, some suppression of material facts and other things, or by a misrepresentation, or it is obtained by collusion, or it is rendered by a court not competent to render it, then section 40 would not come there. That previous judgment would not bind the parties. It is a nullity. It is passed by a court which had no inherent jurisdiction or jurisdiction over the subject matter of the suit. All of us know there are three kinds of jurisdictions: territorial, covered by 16 to 20 CPC; pecuniary jurisdiction, not covered by CPC but by the Karnataka Civil Courts Act; then jurisdiction over the subject matter, about which you will get an inkling if we read section 9 of the Civil Procedure Code. What the courts have held is, if the trial court did not have territorial or pecuniary jurisdiction, the judgment is not a nullity, the judgment is not void. Section 21(1) subsection 1 CPC specifically says that the appellate court cannot reverse the judgment of the trial court only on the ground that the trial court had no territorial jurisdiction, unless the issue regarding territorial jurisdiction was taken by the defendant at the earliest possible opportunity and before the issues were raised or settled, and unless justice has suffered and prejudice is caused to the party by the trial court assuming territorial jurisdiction when it had none. Subsection 2 of 21 speaks in similar words about pecuniary jurisdiction. Section 99 CPC says the appellate court in the first appeal cannot reverse the judgment of the trial court only on the ground that there was misjoinder or non-joinder of causes of action and parties. Non-joinder of necessary party would entail a dismissal of the suit, but not affecting the jurisdiction of the court. So, if we read section 99 CPC in isolation, we find it to be directly in conflict with section 21(1) and 21(2). We have a beautiful decision of the Supreme Court in this regard. AER 1954 Supreme Court 340, where the Supreme Court has said, well, if we just read section 99 CPC in isolation, certainly one is justified in coming to a conclusion that want of territorial or pecuniary jurisdiction would render the judgment a nullity, and the appellate court can interfere with the judgment of the trial court only at that ground. Perhaps the matter reached the Honorable Supreme Court in respect of a matter in Punjab or Haryana, I just do not remember it. There in that particular state, there also we have this Court Fees and Suits Valuation Act. Section 51 of the Karnataka Court Fees and Suits Valuation Act corresponds to section 11 of that particular state Court Fee Act. The argument of the counsel for the appellant or respondent was also taken into consideration. If this is all the effect of section 99 CPC, then the submission made by the counsel has to be accepted and the judgment of the trial court would be void. But is that so? The Honorable Supreme Court makes a reference to Section 11 of the Court Fees and Suits Valuation of that state, which I said is in pari materia with Section 51 of the Karnataka Court Fees and Suits Valuation Act. Now, Section 51 of the Karnataka Court Fees and Suits Valuation Act says it starts with a non-obstante clause. Notwithstanding anything contained in Section 99 CPC, the appellate court cannot reverse the judgment of the trial court. Maybe I have not reproduced in the very same words, but that is the substance of Section 51 of the Karnataka Court Fees and Suits Valuation Act, only on the ground that the suit was overvalued to bring the suit within the jurisdiction of the trial court, unless prejudice is caused, justice has suffered, verbatim reproduction of Section 21(2). Now, most of you know this, but only to refresh the memory of each one of us, the technical term used for a judgment which is void, which is a nullity, that means rendered by an incompetent court, that is a court which did not have jurisdiction over the subject matter, is called quorum non judice. CORAM, quorum non judice. NON-JUDIC, quorum non judice. I have checked its meaning from the law dictionary. Quorum, CORM, who is present. Non judice, it is a judgment as though passed in the absence of a judge. Though it is a judge who has written the judgment, what is its effect? As though a non-judge has written it. Quorum non judice means a judgment given in the absence of a judge, as though a lay person is given. That is the effect of it. It is quorum non judice. So, in this 1954 Supreme Court, what the Honorable Supreme Court has said is, if Section 99 CPC alone is considered as canvassed by counsel, certainly the court at that place had no jurisdiction, the judgment would be quorum non judice. But if we examine Section 11 of the Court Fee of Act of that state, which corresponds to Section 51 of our Act, it is not quorum non judice, because subsequently I got number of judgments of the Supreme Court between 1954, the latest being 2019, Volume 3 SCC 594. 2019, Volume 3 SCC 594. If we read all these judgments, the stress appears to be objections regarding territorial and pecuniary jurisdiction will have to be raised at the earliest point of time, and they are considered as two technical objections. Objections which goes to the root of the matter, that is the very jurisdiction or the subject matter of the suit, is an objection that can be taken even in collateral proceedings and even during execution. Now, a decree is obtained. The usual decisions that we find from between 1954 and 2019 are in respect of these eviction matters. Being not aware of the fact that the Local Rent Control Act or Local Rent Act is applicable or is in force in that area or is applicable to that particular premises, as all of you know, the Karnataka Rent Act of 1999 makes an exception in respect of certain premises, plinth area, rent and all that. Assume that the Karnataka Rent Act or earlier the Karnataka Rent Control Act of 1961 was in force. As on the date the decree was passed, as on the date the suit was filed. Suit for eviction is filed, terminating the tenancy under the Transfer of Property Act by issue of a quit notice. Or if it is a term lease under 111G, it gets terminated after the expiry of the term. First, not deliberately, it could happen by not knowing it. Both the lawyers would be under the impression that the Rent Act is not applicable to that premises, or they have not been able to catch hold of the government notification. Court is also not aware, and therefore we proceed on the basis that an original suit lies. A decree is passed. The decree is confirmed by the highest court of the country. Judgment debtor in the usual course is bound to comply with that decree. In spite of it, he does not vacate. Now the decree holder files an execution petition. Judgment letter has not, of course, he has challenged this decree by way of an appeal and everything. It is still open to him to contend during execution that the decree was passed by a court which was not competent, which had no jurisdiction over this. Of course, prima facie it may look a little injustice, but that's the law on the point. So, how can a void decree or a decree which is quorum non judice be challenged? Number one, it need not be challenged, we can ignore it. You can attack it when execution is late. Or there can be, as the Honorable Supreme Court puts it, a collateral attack. Now, there is a family court in a particular place. It has got jurisdiction. Now, in Karnataka, we have three kinds of these courts. A family court has jurisdiction over the entire district. There is a family court which has jurisdiction only over the district headquarters, not over other places in the district. There are some districts where there is no family court at all. To my knowledge, Bangalore rural district is one where there is no family court at all. I jocularly tell probably families in the Bangalore rural district are happy. Therefore, there is no family court. So, whatever that be, now these are now when there is a family court, section 7 and 8 of the family court act says, well, the jurisdiction of the regular civil court is barred. Not noticing it, or the parties did not know it, court did not notice it. A suit for, a petition for divorce is filed in the regular court, senior civil judge court, a decree for divorce is obtained. Right. Husband has filed a petition for divorce, a decree is obtained. Wife files a suit for maintenance. He says there is already a decree for divorce. True, I admit that there is a decree. Which is that court that has given you a decree? It is the senior civil judge who was not competent. The decree is a nullity. It is quorum non judice. This is called a collateral attack. She has not challenged the decree by way of an appeal. In some other proceeding, what is that proceeding? She has filed a suit for maintenance. She need not even seek a declaration in that suit that the decree of divorce obtained by my husband, the defendant in OS so and so, in MC so and so, is a nullity. There is no need to challenge because it is a collateral attack. It is not a proceeding directly instituted to get over that decree. In some other proceeding, she attacks that decree. That is called a collateral attack. So, there can be a direct attack by filing an appeal or a revision, maybe under the Small Causes Courts Act. There can be a collateral attack in some other proceeding. There can be an attack during execution. It can be totally ignored and can be attacked as at when it is present. So, this of course, I just thought that I should share my limited knowledge of this with this, so that all of us can refresh our memory in this regard. Particularly since I find a few junior advocates here, I thought that I should share this with you. So, this section 44 of the Indian Evidence Act of 1872 is found, as I said, in section 38 of this, 38 of Bharatiya Adhiniyam of this. Then, with regard to this section 45, opinion of experts, we have 39 here. 39(2) says, when in a proceeding the court has to form an opinion on any matter relating to any information transmitted or stored in any computer resource or any other electronic or digital form, the opinion of the examiner of electronic evidence referred to in section 79A of the Information Technology Act is relevant. So, as I said, some provisions of the Evidence Act of 1872 either have been amended or added or modified so as to bring it in tune with the Information Technology Act and the technological advancement that the country has made in recent times. This is one such, what shall I say, not an amendment as such, one such provision which we find to be new enactment. Now, as I repeatedly said, we don't find much of a change in other provisions. Since the purported object of the Adhiniyamas is to see that the advancement in science and technology is taken care of. I only need to draw your attention and refresh my memory with regard to those provisions of the Adhiniyama which deal with these electronic records and electronic evidence. I must candidly confess before you that my own knowledge of digital evidence or electronic evidence is very limited. I think I in fact told Radha also, you will be a better person to answer those questions than me. I must admit it, because I don't want to say something about which I am not myself familiar. But having gone through these provisions, I have found that there are some new sections here and there, some kind of a tinkering or modification, where they specifically deal with this electronic evidence. Section 2, subsection 2, I already read it. Then we have this primary evidence. There section 61 of the World Act. Here it is 57. 57 of this Adhiniyama corresponds to section 62 of 1872. 1872, primary evidence 62. Here it is 57. Primary evidence means the document itself produced for the inspection of the court. Explanations 1 to 3, same thing as we find in 1872. There are 4 more explanations, 4 to 7. All of them relate to these digital records. Explanation 4, where an electronic or digital record is created, stores, such storage occurs simultaneously or sequentially in multiple files. Each such file is primary evidence. 5, where an electronic or digital record is produced from proper custody, such electronic and digital record is primary evidence unless it is disputed. Explanation 6, where a video recording is simultaneously stored in electronic form and transmitted or broadcast or transferred to another, each of the stored recordings is primary evidence. Explanation 7, where an electronic or a digital record is stored in a multiple storage spaces in a computer resource, each such automated storage, including temporary files, is primary evidence. These are some technical details about which an expert in the field can better explain to us, or those lawyers and judges who are already acquainted with this will be in a better position to explain. I have repeatedly confessed to myself before you that my own knowledge in this information, my own information about this information technology is very limited. Well, I am only bringing to your notice those material changes in that regard. Then, section 65A of the Act of 1872, the contents of electronic records may be proved in accordance with the provisions of section 65B. Now, this is 62 in this Bharatiya Adhiniyama. The contents of electronic records may be proved in accordance with the provisions of section 63. What is 65B in 1872, about which there are good number of judgments of recent times, is section 63 in the new Act. Here, of course, we find some new expressions. Semiconductor memory. These are certain new expressions. Notwithstanding anything contained in this Adhiniyama, any information contained in an electronic record which is printed on paper, stored, recorded or copied in optical or magnetic media or semiconductor memory, which is produced by a computer or any communication device or otherwise stored, recorded or copied in any electronic form, shall be deemed to be also a document if the conditions mentioned in this section. Those conditions are found in subsection 2, a reproduction of what we already find in section 65B. Then subsection 3 of this 63.3 is also a reproduction of 65B, and then that certificate is referred to. What the certificate should contain is all given here. As all of you know, we have good number of decisions on that point starting from Anwar Pasha, and the matter was referred to a larger bench to ignore the conflicting decisions in Anwar Pasha and Shafi Muhammad. As all of you know, the larger bench decision is in this Arjun Pandit Rao Kotkar, that is 2020, volume 7 SCC, page 1. 2020, volume 7 SCC, page 1. Now, supposing if it is that certificate is not produced at the initial stage, could it be produced? This has also been considered by the Honorable Supreme Court in a few other decisions. The first one of them is 2017-8 SCC 570. 2017-8 SCC 570, Sonu versus State of Haryana. Then followed by 2018-16 SCC 273. 2018-16 SCC 273, Union of India versus Ravindra V. Desai. Then again a matter from Karnataka, 2019, 7 SCC 515. 2019, 7 SCC 515, State by Karnataka Lokayuta Police versus M.R. Hiremat, wherein this Sonu and Ravindra Desai have been referred to. Then we have a latest one, the decision, there is a note in the decision itself, non-reportable. Anyway, this decision also makes a reference to Sonu. This is in Criminal Appeal 1889 of 2010. Criminal Appeal 1889 of 2010. Date of judgment is 24/10/2019. Rajender versus State. Then one more we have, 2023 SCC Online 1447. 2023 SCC Online 1447. The date of the judgment is 6/11/2023. This is special leave petition, criminal 6548 of 2022. Special leave petition, criminal 6548 of 2022. This is in State of Karnataka versus T. Nazir. This Ravindra Desai and M.R. Hiremat have also been referred to. It can be received at any stage if trial is not yet over. These are certain things which I wanted to share with you. I must once again thank.
Shall I call on mic?
Yeah, just closing. I must once again thank the Honorable President and all the governors of the Karnataka Mediation Center, the Director, and all the mediators, most of whom are my good friends who are here, senior advocates who are present here, officers attached to the Karnataka State Legal Services Authority, for giving me an opportunity to go through this Adhiniyama, refresh my memory of 1872 Act, and spend this happy evening with you. So thank you once again for the opportunity and for patient hearing. With this I am done. If anything relating to electronic evidence, I have confessed at least 4 times. We see a number of persons in the audience who are better equipped to answer questions regarding electronic evidence. Well, the question may be directed to him or her, and he or she would answer their questions with regard to electronic evidence, and I would also learn from him or her with all humility. Thank you. Special thanks to Srimati H.R. Radha for giving this opportunity. And we have one my good friend, Mr. Ravindra. He had pleaded his inability, he has joined us. Well, I must also tell, though I had come to this mediation center after it was rechristened as Karnataka Mediation Center, this is my first visit to this. So I had come here twice or thrice. Mr. Prashant Chandra had organized some one or two such programs regarding amendments to the specifically fact enforcement of joint development agreements. I think I came here twice or thrice, and this day, of course, I have come to this building in connection with various programs of State Legal Services Authority, and today in the Karnataka Mediation Center, I am given this opportunity. I am extremely glad.
Sir.
I have only one thing to tell you, to apologize. Because of my, speaking to the judicial officers newly recruited in the academy for the last 10 years, my tone appears to be like that of a teacher. Kindly excuse me. Please don't mistake me. I really did not mean it. It has been my style for the last 10 years, repeatedly telling the same things, because they are youngsters. I want to see that things get impressed. I know the composition of this audience, but still habits die hard. I really meant no offense to you, but I must apologize to you for that tone. Please don't mistake me, that's all.
Sir, before we conclude, are there any questions that you would like to ask, sir?
Other than electronic evidence.
Not electronic evidence. Yes. Sir has put a rider. Anything else that you all would like to clarify? Because it's not every day that we get such a learned person who would address us, and peppered with a little bit of humor and light moments. We are indeed blessed. So, if there are any questions that anyone would like to ask, I think sir would be. Sir.
Yes.
Mike.
So that everybody else can answer.
No, whether this was required, the whole exercise was required, since you said that it is only a cosmetic change.
Yes. Well, though I have retired, I still consider myself to be a part of the judiciary. A little delicate for me to answer. But anyway, to answer your question, I think at least as far as this Adhiniyama is concerned, well, it was not required because I don't find. See, this has stood the test of time for 152 years. Right? We have dealt with this. I personally see there is nothing wrong in the act. See, witnesses say something. If the witnesses have respect for the truth, truth emerges. Whatever be the view that the judges state, or whatever may be the contentions that the lawyers urge, if truth is presented as it is, I think there should be no difficulty for us. Maybe there are some technicalities regarding marking and other things. Some such systems are required because parties go on making applications, produce documents and all that. Of course, CPC and CRPC also have taken care of that. Sufficient opportunities are given. Anyway, since I have asked this question, I must honestly tell, having gone through, not intensively but extensively, the provisions of the Adhiniyama, I find there was no need for that. I am not commenting on this. I am just giving my. Anybody can have a different opinion about it. Absolutely, I have no quarrel with that.
Sir, now as a judicial officer, retired judicial officer, do you find difficulty in implementing this?
I don't find any difficulty. My own personal difficulty is about that electronic evidence.
Any other questions?
And fortunately for me, the Madras High Court has said the arbitrators are not required to follow section 65B, and therefore, of course, everybody files that certificate, there is no problem for me. That I am jocularly telling. Otherwise, I don't have any problem in. I had no problem in dealing with this Evidence Act on the bench. So, I don't think that this is a problem.
So, also section 19 of the Arbitration Act?
No, that you have enlightened me on section 19 of the Arbitration Act as a counsel appearing before me in the arbitration proceedings on a few occasions. Absolutely no problem with section 19.
Any other questions? We'll wind up.
All right.
Sir. Sir, we...
So, I would like to tell Mr. Srimati Radha, as and when any occasion comes, if you feel that I can spend my good evening happily in the mediation center,
Sure, sir.
so long as
We do require.
so long as Judicial Academy does not get affected,
Thank you, sir.
I'll be happy to come and spend some good time with all our good friends.
Thank you, sir. Thank you. Yes.
Sir, we express our deep gratitude to Sir S.R. Somshekhar, retired Principal and District Sessions Judge, Bangalore, for the most enlightening insight into the Bharatiya Sakshya Adhiniyam 2023. So we deeply appreciate that you have taken time out of your busy schedule as arbitrator, academician, and other commitments to spend your time here and to enlighten us on this new act. We would also like to thank the Board of Governors, Justice Sri Srinivas Harish Kumar, President, Justice S.G. Pandit, Justice Ashok S. Kinigi, Justice Suraj Govindraj, Justice Jyoti Mulimani, Justice M.I. Arun, for being here, present virtually for this program. Our Director, Srimati H.R. Radha, our Deputy Director, Sri Vasudev Guddi, Sri Jai Shankar, Member Secretary, KSL LSA, Sri Raghavendra Settigar, Deputy Secretary, KSLSA, Sri P.N. Balasubramani, PRO, KLSA, Sri Sharat Chandra, Assistant Secretary, KLSA, Assistant Registrar General and Registrar General, Dharwar and Kalburgi Bench, Srimati Amrita Sindur, Assistant Director of Karnataka Judicial Academy, Registrar Computers for providing us the Zoom platform to live this evening's program live, and Sri Velu for taking the trouble of streaming this program live. My dear brother and sister mediators of the mediation fraternity, thank you for being here and making this program a very enlightening one. And thank you, sir, for leaving if this was a bird's eye view and cursory, you said a cursory glance that you gave into the act. Sir, I think we all would be waiting for a chance when you go through all these acts and give us a full-fledged, in-depth study into what it is. The only thing that I take from this evening is that I don't think we need to go back to school to study this new act, since it's merely mildly put cosmetic, and we are left to the thought whether this was necessary at all.
I am at the command of the Honorable President and the Board of Governors of the Karnataka Mediation Center and also the Director. I am once again thanking all the Honorable Governors who have joined online. My deepest sense of gratitude to all of them.
Thank you so much, sir. Thank you.
So I had expressed my readiness and willingness. I have also done it. ಬೇಡ ಅದು ನಾನೊಂದು ಆರ್ಡ್ರಲ್ಲಿ ಇಟ್ಟಿರ್ತೀನಿ. ಅದು ಅವರು ಶರತ್ ಚಂದ್ರ ಅವರು ಇದ್ದಾರಲ್ಲ, ಅವರೊಂದು ಪ್ರೋಗ್ರಾಮ್ ಕರೆದಾಗ ಈ ಆರ್ಡ್ರ್ ಏನೋ ಮಿಸ್ ಆಗಿ ಕೆಳಗಡೆ ಬಿದ್ದೋಗಿದ್ದನ್ನ ಅವ್ರು ಗಮನಿಸಿ ಅದಕ್ಕೊಂದು ಬೇರೆ ಏರ್ಪಾಟು ಮಾಡಿ ನನಗೆ. ಅದಕ್ಕೋಸ್ಕರವಾಗಿ ಈಗ ಇನ್ನೊಂದು ಸರ್ತಿ ಬೀಳ್ಸಿರೋ ಅವ್ರು ಇನ್ನೊಂದು ಸರ್ತಿ ಏರ್ಪಾటు ಮಾಡ್ತಾರೆ ಈಗ.